Block.
Mr. Chief Justice, and may it please the court, B.P.J. signed up for school sports because she was an 11-year-old girl starting a new middle school who wanted to meet people, make new friends, and be part of a team. West Virginia argues that to protect these opportunities for cisgender girls, it has to deny them to B.P.J. But Title IX and the Equal Protection Clause protect everyone, and if the evidence shows there are no relevant physiological differences between B.P.J. and other girls, then there's no basis to exclude her. In thinking through the Title IX claim in particular, it's important to distinguish between how Title IX operates as a general matter and how it operates outside the context of athletics. And I'm glad that we're doing that this morning. Instead of focusing on athletics, West Virginia argues more generally that this court's reasoning in Bostock does not apply to Title IX. To distinguish Title VII from Title IX, West Virginia argues that Title IX protects groups instead of individuals and applies only when sex is the sole cause of adverse treatment. That approach takes a wrecking ball to the text of Title IX and the structure of this court's anti-discrimination precedents. It would dilute Title IX's protections for everyone, not just transgender students and not just in the context of sports. West Virginia's law treats B.P.J. differently from other girls on the basis of sex, and it treats her worse in a way that harms her. Outside the context of athletics, that's all B.P.J. would need to establish a Title IX violation. But the Javits Amendment provides extra breathing room for reasonable regulations that take into account sex-based differences in athletics to provide equal athletic opportunity for everyone. West Virginia's exclusion of B.P.J. does not fall within that framework. Unlike the exclusion of a cisgender boy, excluding B.P.J. doesn't advance any interest in ensuring overall fairness and safety. And unlike the case of a cisgender boy, excluding B.P.J. from the girls' teams excludes her from all athletic opportunity while stigmatizing and separating her from her peers. I welcome the court's questions.
Doesn't your claim ultimately depend on the existence of sex-segregated sports?
Yeah, no, I don't think so, Your Honor. I think this is similar to Morales-Santana, where the claim was an equal protection claim.
Well, I mean, let's say there were no Title IX requirement for sex-segregated sports.
Yeah, well, if there were no Title IX requirement, and well, I don't think Title IX requires sex-segregated sports.
Well, permits.
If there were no Title IX and all the sports were co-ed, then she wouldn't be subjected to disparate treatment on the basis of sex. So I think the claim is the discrimination, and it's perfectly possible to.
So doesn't that suggest that you're a subcategory of the relevant class of female athletes? Isn't that your point?
Yes. Well, for the equal protection claim.
Well, but you're not. My point is that you're challenging a category that does not exist in the statute, but is dependent upon the existence of a category in the statute that you're not challenging.
Well, I wouldn't put it that way. I would put it the way as there's a classification that we think is valid as applied to most people, but is invalid as applied to a discrete subset of those people. But I don't think the success of that equal protection claim hinges as an a priori matter on the existence of girls' teams. There are lots of ways to remedy an equal protection violation.